I know there's been a great deal of discussion this morning, which actually followed our conversation yesterday, about the effect of the FISA law and the president, whether the president has the authority to violate that law. I would just like to associate myself with Senator Feinstein's excellent description of congressional intent when passing FISA. And I must say that your answer to her appeared to be directly contrary to the Youngstown approach to executive power, which you and I discussed in detail yesterday, and you appeared to accept as important and valid law. The Supreme Court has held that executive power is affected very significantly by what Congress does. So it sounds like overnight you've gone from being agnostic, as you and I have gone back and forth since our first meeting on this question, to holding what is a rather disturbing view. You have said today that you believe the president may violate a statute if he is acting within his Article II authority. Now that position, which I find alarming, makes it extremely important to know what you believe the exact scope of the president's Article II authority to be. So are you telling the committee, Judge, that any time the president is acting to safeguard the national security against a terrorist threat, he does not have to comply with statutes?
You've suggested that I've gone overnight from being an agnostic to being a heretic. And
explain why you haven't.
I haven't. I think all I'm saying is that obviously I recognize the force of Justice Jackson's three-step approach, but I recognize also that each branch has its own sphere of authority that is exclusive to it. For example, just to take an example that has nothing to do with the subject under discussion immediately, you have the exclusive authority to vote me up or vote me down for any reason or no reason. If I am displeased with the result and displeased with the reason, I could not validly go down the street to the courthouse and file a lawsuit and claim that I had been denied a right, even if I got some judge who was willing to entertain the lawsuit and even if I prevailed. There are a lot of ways you could describe that outcome, but the rule of law isn't one of them, because the authority belongs only to you. There are areas of presidential authority. I also said that we are not dealing here necessarily with areas of black and white. I understand that, which is why it's very important that push not come to shove on these questions, because the result can be not simply discord, but disaster.
Well, Judge, I'll take your example. In the case of the Youngstown case, people did have the right to go down to a courtroom, and they did it, and they won. And Justice Jackson indicated a three-part test, which your analysis today, I think, renders essentially meaningless. So I believe that this is contradictory, and it does trouble me, and I have great respect for you. And I do believe, as Senator Schumer indicated yesterday, you have a similar opportunity to change the tenor of this administration the way that Levy did in the prior history of this country. Let me just say with all respect that this area is perhaps the most important one where the repairing has to be done. The getting away from this notion of sort of an ever-expanding, infinite Article II power, and I would ask you to take that very seriously. Let me switch to a different topic. As you know, the decision whether to seek the federal death penalty in any given case rests with the Attorney General alone. Attorney General Gonzalez has been criticized for not being personally involved in that decision-making process. In one case, he apparently refused to speak personally with a U.S. attorney about a case in which he ordered that the death penalty be sought over the U.S. attorney's objections, and then he told this committee that this was one of the reasons that particular U.S. attorney was fired. How personally involved would you be in decisions about whether to seek the federal death penalty?
I am going to be personally involved, and I am going to review every such decision. I took sentencing seriously when I was a judge. I never had occasion to pass a death sentence, although I did preside over cases where that was at least a possibility at various points in the case. There is obviously no penalty that is analogous to the death penalty. There are other penalties, and there is that one. And that means that I'm going to review every such case in excruciating detail. We have a system in place, as I understand it, that was put there, I believe under Attorney General Janet Reno, in which we have tried, already saying we, it's presumptuous, in which the department has tried to assure that the decision about whether to seek the death penalty or not seek the death penalty depends only on the underlying facts of the case, the history of the defendant, the acts involved, the seriousness, obviously the seriousness is always ultimate, but the cruelty that accompanies a murder and other indicia.
Will you refuse to speak personally with a U.S. attorney who disagrees with your decision and wants to discuss it with you?
That's a difficult question for the following reason. If there is a defendant in a jurisdiction where the United States attorney wants to speak to me, then it may very well be that that defendant's crime is no better, that his background is no better than the background of a defendant in a jurisdiction where the United States attorney, because in that jurisdiction they're more accustomed to or inured to or favorable to the death penalty, the United States attorney doesn't feel he wants to intervene. The system was supposed to treat, the system that was created in the department is supposed to treat those two people the same way.
But why wouldn't you speak to the U.S. attorney about this? I mean, you didn't specifically say that, but that was my question. Would you agree to at least discuss it with him?
I would want to have that United States attorney's views made known to me. I don't want to be in a situation of succumbing, if you want to call it that, to a plea by a United States attorney who does not want for good and conscientious reasons. And there are people who have good and conscientious reasons, and I recognize that.
You think
does not want to seek when the same case may be getting different treatment in another jurisdiction.
Should the additional cost of pursuing the death penalty rather than a life sentence be a consideration?
There's a whole range of considerations. That's, I guess, one of them.
All right. Let me move to another topic as I'm running out of, unless you feel you need to elaborate there.
No, I just don't want to create an incentive for, obviously the more costly you make it, then the more the equation tends against it, and we shouldn't be doing that.
Judge, as is the case in every federal agency of all three branches of government, there are gay, lesbian, bisexual, and transgendered Americans serving honorably and effectively at the Department of Justice. The department sponsors commemorative events to recognize the contributions of various minority groups, but under Attorney General Ashcroft and Gonzalez, in contrast to Attorney General Reno, it has refused to do so for the GLBT Americans. In addition, while DOJ Pride, an organization of GLBT employees, is permitted to use department space to hold events, it is prohibited from advertising those events on public billboards in department buildings, again, unlike other organizations for minority employees at the department. Similarly, the department refuses to recruit at job fairs aimed at GLBT attorneys, but sends recruiters to job fairs aimed at other minority groups. I am troubled by this. I suppose there is not much to be done about this administration's attitude toward gays and lesbians, but as Attorney General, you would have the power to end this shameful conduct. Will you stop the disparate treatment of gay and lesbian employees at DOJ?
I don't understand the reason for that treatment. When I was a district judge, I interviewed and hired without regard to any matter relating to the personal life of a prospective law clerk, any matter of that kind. And I see no reason why there should be any different standard at the department.
I will take that as saying that you will stop the disparate treatment of gay and lesbian employees at DOJ.
Sounds like I'm going to.
Pardon me?
Sounds like I'm going to.
Sounds good to me. Thank you, Mr. Chairman.